let's transition now to the ERISA requirements themselves. Fine, there's this statute called ERISA that might matter to these people, and these people have different designations under ERISA. But what does ERISA really require? So let's turn to that next. And here we're showing everyone. First, it's a statutory citation. So that's a citation to the U.S. Code, 29 U.S.C. Section 1133. And you can see there it describes what benefit plans have to do when they are adjudicating a claim, and in particular, when they're going to deny some portion of that claim. And you see the legal requirements written into the law right there, little 1 and little 2. They've got to provide notice in writing. It's got to set forth the specific reasons for the denial, and it's got to be understandable to average person, essentially. And then little 2 says that they have to provide a full and fair review of the initial decision denying the claim. So here you have written into federal law and applicable to every single ERISA plan in the country requirements about if a plan is going to deny a claim, what they have to tell people, and in particular, what they have to tell the ERISA participant or the ERISA beneficiary. Okay, so that's the law written into the statute. Then you have a citation to essentially the regulations that have been promulgated pursuant to that federal statute. So these are regulations promulgated by the Department of Labor, and they can be found there at that citation in the CFR. And what these do is they kind of put meat on the bones, if you will, on the statutory requirement that there be a full and fair review and that this information that's understandable be communicated to people. So here you see the Department of Labor laying out in a regulation exactly what that means. So first, and perhaps most importantly, the regulation itself applies to anything that constitutes a, quote, adverse benefit determination. And that, you can go and look in the CFR, that is defined very broadly to effectively mean any decision that results in coverage or benefits or benefit amounts that are less than those promised by the plan's written terms. There is a requirement found in B3 that the claims procedure cannot be administered in a way that unduly inhibits or hampers the initiation or processing of claims. B4 says that there has to be a procedure that allows people to designate an authorized representative to act on their behalf. And Brian made reference to that a moment ago, that the law itself, the regulations themselves require plans to allow their participants and beneficiaries to designate someone else to be their authorized representative. There's F, which lays out deadlines that have to be followed by the plan. Ordinary claims have to be resolved within 90 days. Urgent care claims have to be resolved within 72 hours. Concurrent care claims have to be resolved within 24 hours. Those are black and white requirements that are written into the law, that first in the statute and then as articulated in the regulations. Now that may come as a surprise to some folks, especially the providers who are watching this, because typically, especially in the context of things that providers believe are urgent care claims, oftentimes those will not be responded to within 72 hours. And that, if it's an ERISA plan, that's illegal. Again, you should look in the regulations to see what constitutes an urgent care claim. It's essentially what you would think would constitute an urgent care claim. Deference is given to the provider's judgment about how urgent it might be. Anyway, so the point though is that there are these deadlines that are written into the regulations themselves that apply to every single adverse benefit determination that's issued under an ERISA plan. And then a couple of others. There, G kind of adds color to what it means to tell people why their claim is denied. So here it requires that communication be in writing. It has to contain the quote specific reason or reasons for the denial. It's got to reference this quote specific plan provisions. It also has to identify any guidelines or protocols on which the denial was based and make them available to the ERISA participant or beneficiary. It has to describe any other information that might be necessary to perfect the claim. And it also has to describe the appeal procedures and any deadlines. And all of that has to be included in the letter. In the letter you get the explanation of how that claim is being adjudicated by law needs to contain all of this information. And then finally, we have H, which is a requirement about the kind of appeal. So it requires that each plan has to offer at least one level of appeal that does not give any deference to the initial decision and that utilizes a healthcare professional in the relevant medical field who was not involved in that initial decision. So we wanted to linger on this a little bit and admittedly read you text because our sense is that in the main, these requirements are frequently ignored or violated, and that part of the reason for that is that neither patients nor their providers know about them and insist on them being given to them. And so we wanted to spend perhaps a bit more time on them because they really are, so important.